shoes. Recorded live.
All right. Welcome to our regularly scheduled Wednesday night call. This is the Free Americans call. We have Christian Walters on with us tonight. And before we get started, I'd like to put out a quick disclaimer. I want to let everybody know the purpose for our call is to talk about freedom and what we can do in this country to be free men and women walking on the land. And welcome to the call tonight. Thank you so much for dialing in. We have an exciting show for you tonight. We are not attorneys. We are not giving any legal advice out tonight on our call. Anything that we say should not be construed as legal advice. Anything that you hear on the call tonight, this is, educational purposes only. If you do hear information on this call, go and research it for yourself. We have a Yahoo group, the Free Americans. There's a lot of good information you can download from there. Have to be a member out there in order to join, but membership is free. You can get a lot of good information, but if you do get this information, make sure that you own it. If you hear of a process on the call tonight, or if you get letter templates, make sure that you own those. Don't blame somebody else if your process doesn't work, because if you write it, if you sign it, if you put your energy behind it, then you need to back it up. We are not tax accountants. We do not give any tax advice, nor any legal advice. But we do have an exciting show. I'm excited for our show tonight. So without any further ado, I'd like to turn it over to Christian Walters. He's going to enlighten us on more information regarding trusts. So with that said, Christian, are you there?
Yeah, I'm here. Am I coming through okay?
You sound great.
Okay. We got a motion in here for an ex parte motion for an assignment of bid. Now, that was kind of interesting because I was reading through this thing. And the first point that they're making in this was the loan secured by the mortgage held by plaintiff is guaranteed under the provisions of Title 38 U.S.C. Chapter 37. And I looked that up, and Chapter 38 is veterans benefits, so it's basically talking about benefits. And under Chapter 37, it's housing and small business loans, which again is under the benefits rule. But this ex parte motion for an assignment of the bid was on a house that was foreclosed upon, and the party that brought the action, LaSalle Bank, is now wanting to assign it to U.S. Bank National Association as successor trustee of Bank of America National Association, successor by merger to LaSalle Bank National Association, as trustee for Morgan Stanley Mortgage Loan Trust 2007. So what it looks to me like is this bank has brought a mortgage foreclosure against the party, foreclosed upon the property, and sold the property, now wants to assign their $100 bid on the property to the rightful owner, who is the real party in interest that should have been the party making the claim to begin with.
Were they acting as a nominee or an agent for them,
well,
for the real party in interest?
They brought this action in their own name. LaSalle Bank knew it was not the real party in interest, but brought this case in its own name with standing as hiding as an agent for U.S. Bank National Association, and without joining the real party in interest. So I'm thinking a motion to set aside could be put into this case because they had failure to join the real party in interest, which was this U.S. Bank, or at least this document itself purports to be their own testimony, as there could possibly be a prima facie evidence case against them that there was another true real party in interest, and they had no standing to bring this foreclosure action. So what's interesting about this Title 38 is that this looks to be all about insurance, because it's the U.S. Code, and in Section 3732 it talks about procedures on a default. And it says, in the event of a default in the payment of any loan guarantee under this chapter, the holder of the obligation, which would be the party that foreclosed and wants to sign their bid now, so the holder of the obligation shall notify the secretary of such default. And basically what it's saying is they're going to get paid for the mortgage in default on the insurance. as well as hold the property and sell the property. And Harold sent me something by email on a disclosure that he brought in that somehow he got a hold of it, and it was about Deutsche Bank was doing the very same thing, and it finds out that most of these banks are getting paid 4 times over on the foreclosures. They're collecting on the insurance, they're selling the houses, and they're collecting from the people. What a scam. What a scam.
Yeah, it is.
But I don't know if anybody's ever got something like this. Ex parte motion for assignment of bid. But it says the plaintiff was a successful bidder at the foreclosure sale held such a date, and that the bid should be assigned to U.S. Bank National Association. Now, I wonder why they should be assigning it to them. Well, they must be the real party in interest. Well, if LaSalle Bank was defunct, so to speak, because they were bought out by a merger of some other bank, where was that party at? So anyway, that was a little piece of information I ran across there. Harold, did you have anything to add on that? Are you on?
I have somebody from New York on. I don't know if it's Harold, though. Harold, are you out there? You must not have dialed in yet, Christian. Okay.
So that was a little piece of information. I'm wondering whether or not people that have defaulted might be able to use this Title 38 code in such a way as to you apply for the default insurance.
Oh, okay.
I haven't read all the way through it, but that could be a possibility. Instead of the banks collecting on the insurance, you may be able to, as maybe the real party in interest, as the real man.
Yeah, the living soul.
Right, because the default would be up against the straw man entity. Possibly the real man could come in as another party, maybe as an intervener, and possibly through a trust application.
Okay. Have you heard any recent court decisions regarding foreclosures? I think I got one recently about MERS assigning and how they don't have any authority as being part of the mortgage process.
Yeah, just that landmark case out of Kansas City and a few others, Arkansas.
Did you read through that?
I don't have the case in front of me, but there was let's find that quick. It was an article written by a lady, and her name was Ellen Brown. And basically, she said that the title of the article was "Landmark Decision Promises Massive Relief for Homeowners and Trouble for Banks."
Yeah, that sounds like the one I got too.
There was also a case in Delaware.
Delaware? Yeah.
Yeah, bankruptcy case, and it was the same thing. It was against MERS.
It says the real party in interest concealed behind mirrors have been made so faceless. However, there is now no party withstanding to foreclose. Kansas Supreme Court stated that Mears' relationship is, quote, is more akin to that of a straw man than to a party possessing all the rights given by a buyer. And then the court opinion, it says, by statute, the assignment of the mortgage carries with it the assignment of debt. The deed, the event that a mortgage loan somehow separates interest of the note and the deed of trust, with the deed of trust lying in some independent entity, mortgage may become unenforceable. The practical effect of splitting the deed of trust from the promissory note is to make it impossible for the holder of the note to foreclose unless the deed of trust is the agent of the holder of the note. With the agency relationship, the person holding only the note lacks the power to foreclose in the event of default. The person holding only the deed of trust will never experience default because Only the holder of the note is entitled to payment under the underlying obligation. The mortgage loan becomes ineffectual when the note holder did not also hold the deed of trust. So it mirrors that the straw man lacks standing to foreclose, but so does the original lender, although it was the signatory to the deal. The lender lacks standing because the title had to pass to the secured parties for the arrangement to legally qualify as a security. The lender has paid in full and has no further legal interest in the claim. Only the securities holders have skin in the game, but they have no standing to foreclose because they are not signatories to the original agreement. They cannot satisfy the basic requirement of contract law. Plaintiff suing on a written contract must produce the signed contract proving he is entitled to relief.
Just a big shell game.
Yeah, nobody knows who the real owner is.
And nobody can prove they're the real owner because nobody has the original note.
No.
The wet ink signature.
Well, I guess there's a few other cases that have supported this. There was one Supreme Court in Kansas about mortgage electronics registration system, March 19, 2009 case from an appeal, and a few other cases also, but I haven't really read all through them. And somebody was saying there was one in Florida here that's pending, so I don't know. It looks interesting for the impact of the 60 million fatally flawed mortgages that are coming up and possibly for foreclosure on those.
How do you combat that when it relates to non-judicial foreclosure states where they just send a letter out to the homeowner and whether they dispute it or not, they after 30 days, if they don't dispute the debt, they just serve the homeowner, and then they take it to sheriff's sale, and voila, the deal's done.
Well, I think I got to come in with an independent action and sue them in court and get a stay put on that, or a temporary restraining order, preliminary injunction, whatever you want to call it.
Yeah,
okay, yeah.
Quiet title action.
Yeah, quiet title action. Yeah.
I got to mute off for a sec. Go ahead, Harold.
No, I said you can do it with a quiet title action. And actually, you can do it before their foreclosure process fully matures. Like
come in with rescission signatures and all that other stuff, revoke power of attorney and all that. That'd be also maybe in addition to all that. On top of it. How you doing, Harold?
Not too bad. Sorry I was a little late there. I had a client on the line, so I couldn't get over quick enough. So what did you cover in the beginning?
I was just talking about that ex parte motion. Ex parte motion for assignment of bid.
Yeah, that's strange.
And how that was applying into that 38 U.S.C. Chapter 37, which was talking about benefits, and it looked like they were trying to collect the insurance.
Right.
I was thinking maybe somehow that Title 38 could be used to where the person who has been foreclosed upon could make application to the secretary and maybe claim the insurance and recover from the default that way. Maybe coming in as the real party in interest as the real man, and since the straw man was the one who defaulted.
Even if you came in as the straw, that would be more of the real party of interest than the bank, because that whole scenario, they took and stole a note, converted into a security. Matter of fact, I heard somebody speak today that what they're doing now, being that everything is basically under international law. According to this one source, they're saying that we came into international law with NAFTA. And so now with these notes, what happens is before the ink is dry, they converted the note into a security that's governed, I think, by 2 and 8 rather than, or is it 2 and 9 rather than 3 and 8? I forget exactly which ones was which. Because normally when we think of notes, we think of Article 3, UCC, and 9?
Well, yeah, 9 is securities.
Well, securities, right.
8-9 is securities, yeah.
Yeah, when it becomes a security. But they were saying something about Article 2, which I'm not familiar with.
That's contracts for sales.
Yeah, so I got to find out what this guy is talking about. This guy named George Mason out in California. Now he's really good with administrative law, but I question him sometimes on this mortgage stuff. So I caught him in a couple times where it was not quite accurate.
What's his name again?
George Mason.
Mason.
Yeah, he's really good with that administrative law. Matter of fact, I heard he was one of the drafters of the code.
Oh, he had something to do with writing it?
Yeah. He was part of the team. But he's sort of like working on the other side now.
How come? He fell out of dishonor?
Well, I don't know. Perhaps he saw the light. A lot of people, they get into those government positions and they actually think they're doing a good deed until they get inside and then they see the dirt.
And they want to get out and wash their hands clean.
Yeah.
Most of those workers there are kept in the dark, too, so they don't really know that they're participating in the fraud.
In most cases, you're correct.
Yeah, they think they're actually doing good. It's the ones that are sitting up in the office towers high on the top of the buildings. They're the ones that are perpetrating everything. The CEOs, the CFOs, the high-level government agents.
Do you see many people on the line?
Yeah, we got about 30 callers in tonight.
Oh, okay. Well, we can let Christian go then. Let him do his thing.
Yes. By the way, callers tonight, if you have any questions while Christian's talking, you can go ahead and hit *8 on your phone, and when I see it, I'll unmute you. So we'll let Christian talk some more, and then we'll open it up to the calls. Any questions?
I had a bingo last night on some of the stuff you sent me over, Harold. I was reading that one case through there, and I was coming through on page 5. It was talking about Mears on that. It said that Mears' primary contention is that it has standing by virtue of the fact that it was named as the beneficiary under the deed of trust, and that the trustor, it says in quotes, the maker of the note, recognized Mears to take actions of the beneficiary or that of the nominee of the beneficiary. I picked up on that right there, that the trustor is the maker of the note.
That's you.
Yeah, so that's 3-105. So the maker is really talking to the note, but they're also saying in that quote there, right out of the Supreme Court there, that they're saying that the maker of the note is also the trustor or the grantor.
Yeah, because sometimes you see it as trustor, grantor, or the settler. They're basically all the same positions.
So that's confirmation that the grantor was the maker of the note per Supreme Court. So at the mortgage foreclosure, or let's put it, mortgage closing, I mean, when we bought the house, the presentation of the note, if it would have been in trust, then we should have been able to get the original note back because it was a trust deposit, but we never expressed that trust where that note was made by the grantor, and therefore it was misconstrued under debtor-creditor as a debt. So that's just more evidence to support that the grantor was the maker of the note, and it can be put into a trust deposit so that your UCC-1 financing statement with your security agreement would become a trust receipt, and a receipt would be a record of a payment receipted. And I don't know if we talked about that last week, but I think the week before that we might have mentioned that about.
No, you talked about that on your show, not on this.
It wasn't my show, I forget, yeah. But those definitions of trust deposit, special deposit out of Black's Law, and I think to get, you have to go back into maybe some of the older Blacks to get, I think it was the trust deposit definition. But the trust receipt can be gotten out of Black's Law 8, and I had the Bank Officer's Handbook of Commercial Banking Law under a section there that defined the special deposit as being a trust deposit. So it kind of made a loop back around in confirmation with different sources. Actually, the confirmation was in the Black's Law dictionaries that I think the information we were looking for proved that the note actually paid the mortgage at the closing was really in Black's Law, where it says under this section 19.02 under the Banker's Handbook, it said that the special deposits may take a number of forms. Sometimes they are a means of holding funds in litigation or trust funds. So a trust funds, that would be your promissory note that was created by the maker, the grantor, but you never put it into trust at the closing by expressing the trust, and now you put it under debtor-creditor law, and your receipt of payment, which should have been your UCC-1 filing of your security agreement, now became a debtor-creditor filing, and now you owed on it instead of it being paid as a receipt. But then the definitions is the key to bringing that out, where everybody knows that a receipt is a record of payment, and then a trust deposit, which I didn't know about 2 weeks ago was also a special deposit. And as a special deposit or a trust deposit, now we're talking about trusts. And the trust receipt under Black's Law was a pre-UCC security device now governed by Article 9. But skipping down to the important part, it says, today there must usually be a security agreement coupled with a filed financing statement. Well, that's a UCC-1. And that is the definition of a trust receipt. And a receipt is a record of a payment. So then I made a comment on my show. I don't know if anybody picked up on it, but it was very important because really you have the key right there on how to negotiate an NDI. Are there any light bulbs going on?
Actually, my light bulb seems to be getting ready to go out. I was up all last night.
Pulled another all-nighter, huh?
Yep. On Jason's thing.
Yeah.
That'll get you too many gray hairs real quick.
Yeah, they definitely coming in too.
Harold, we got to get you a life.
That's all going to change soon, isn't it, Dave?
You know, rumors have it.
Nice to hear your voice, Dave.
Nice to hear yours, Harold. Hey, you guys might want to check out what you were talking about. I was sitting here listening, and might want to check out Title 18 686. I think that's a portal.
Has to do with trust there?
Yeah.
Anything in specific you have on mind?
Yeah, just basically tells you, what your empowerment is as far as being a grantor. But what you were talking about earlier, Christian, was, I think you have to do a combination of things on this, guys. I think you have to do, what's that term in martial arts? You have to sweep their legs. And I think you start that off by, putting in your notice to cancel. So a lot of that Karen Tappert stuff, but I think Karen was missing some components. But I think you need to apply all that stuff. I think you need to revoke their power of attorney 17 ways to Sunday and shut down every single means and way that they can to come back so that they can't redraft the contract on you, including rescinding your signature, including canceling the contract, and then go back in and redraft the trust to your benefit and take it away from them.
Right, I think you're right. The fact that we're not expressing the trust properly leaves room for them to construe it.
Well, yeah, and we've got evidence that shows that if you go in and you do a trustee termination, we shared that months and months ago, and guys were going in and they were, taking a trustee termination document and they were rewriting, they were firing the trustee and assigning someone else as a substitute trustee and going through that whole process. The challenge, of course, was getting it into public record for some people, which normally just means sometimes you have to take a trip around your local area to 3 or 4 counties until you get it done. But once you get it in and you've got it, date stamped and you got a page number and all, then you can go back and under affidavit, you can put it right back in your own county. And then if you take certified copies of that to the steps, if you're in a non-judicial format, then you can, now you've got evidence that you can put right in front of a trustee's face, and you can put a sheriff on notice that if he doesn't stop it, then he's becoming an accessory. And of course, you'd have to know your laws surrounding all that. But we know that works. The only problem with that is that the door is still open for them to come back and substitute somebody else. So they'll play this little, game of, I think Matthew said it a while ago, they're playing this little shell game with you. And
how can they turn around and substitute somebody else if that power of attorney was revoked?
Well, that's what I'm saying. We weren't doing that. And so I think that's the whole thing. But I think what you also have to align with you and that is you have to come back in and put yourself in the right position within that trust. Because if you're coming at them as a trustee, well, no wonder they're not going to listen to you. It's just like what Christian was talking about earlier with Mears. That made perfect sense to me. If Mears has been assigned a beneficiary, then guess what? They got standing.
No. Actually, no, because in that case that I think you was reading from the Nebraska case.
It was Kansas City.
Oh, the Kansas. Okay, the Kansas case. They actually break that down. On one hand, they said that they do have standing and have beneficial as a beneficiary. However, later in the mortgage agreement, everything cancels that out. Everything is the lender, not Mears. So if you read that decision carefully, it shows that there's a dichotomy in these mortgage agreements.
Well, yeah, because there's confessed judgment, and they've already decided that that can't be. How can you have confessed judgment in your mortgage? That's about as unfair as it
Well,
is.
I think you didn't express the trust properly. They construe it, and they construe it that you're under U.S. codes, under the debtor-creditor law, and then you confess judgment.
Exactly. Well, I think that, there's also the idea that you have to address both sides, the public and the private side of this mortgage. So obviously, on one side, you're coming in as the creditor, and the bank's the debtor. We all know that. But on the other side, guess what? It flips the other way. So,
I'm saying that trust is, when you express the trust, you're not under debtor-creditor or anything UCC or codes. You're like up above. You're in a different realm altogether.
But my point was going to be that you've got two different trusts you're dealing with there. So you'd have to go in and take care of both. And
otherwise, yeah.
Exactly. Because, whether it's assigned or applied, implied or whatever, knowingly or unknowingly, it's still there. So until you declare your status within that, then you're
kind of like master trust versus sub-trust.
I'll take your word for that. So I think, again, it just really comes down to understanding who you really are and what your position is, and the empowerment of the grantor, because nothing happened until the grantor created it. That's why it's a grantor, trustor, settlor. The problem what most people they're failing to understand is the settlor side of things. And how do you do that? How do I position myself? What documents do I create? Where do I put this in? What happens if I do this before the foreclosure or after the foreclosure? I think some people have got, I think they've got a shot. If they've gone to foreclosure, you do one of two things, and we all realize that most people just give up. They just walk away. They're beaten down. They don't think they can win. They have, you know what I mean? I mean, it's such a degrading, debilitating type process that they put you through. So people just walk away. But, who's going to be the first one? And I'm sure it's already happened. But who's the first one who's gotten foreclosed on and is going to come back and say, you know what? Tell you what. You want the house? You can have the house. It's all yours. Keep it. No problem. I have no problem giving you the house. As a matter of fact, I'll tell you what I'll do. I'll clean the carpets and I'll have fresh cookies baked for you. So that's permeating through the house. But here's what I want. I want the note back, because you can't have both. And I'll tell you what, if I found out that you have taken that note and you've altered it and you've turned it into a security and then you've traded it on Wall Street, well then now you've got a problem, because I want all that back too. I want every dime that you've made an interest. Right. So I think that if that gets into federal court and that comes down through the airways, that's where now I think you can position yourself, hopefully, because I think this is just my humble opinion. Until we take out a law firm and let that permeate through the country, we're fighting onesie-twosies. Because let's face it, there are some people I think they're getting victories. But I think what it's going to come down to is that once you can put the DNA on a law firm, and based on the fact that we all know that they eat their own young, and we also know that they work by committee. So, I think once we get to that position with, say, a couple of hundred really pissed off people, let's say, that got screwed by Deutsche, Rothschild Deutsch.
I call them douchebank.
Yeah, douchebank. The fine folks that was one of the main financiers of the Holocaust, who are literally in America right now stealing it one property at a time. Again, I come from the place of never underestimate what a small group of people can do to change the world. Indeed, it's the only thing that ever has.
Right. So Paul Revere did, or give me liberty, give me death.
That's look what Mothers Against Drunk Driving did. That was one mother who was really pissed off that her son's life was taken from her, and she wasn't going to allow people to get behind the wheel of an automobile and go recklessly abandoned, go out there and drink and kill people, and then let it happen 3 or 4 times, and the next thing you know, the guy's out, and he's killed 3 people, or he's got 7 or 8 DUIs, and he's out there driving. So
but
I think
we need to get more people involved, and a mind is a terrible thing to waste, and everybody is mostly wasting their minds. We could, if we had the wherewithal to get our heads out of our asses, so to speak, put this together and conquer it.
Well, I think we've got the knowledge. I think we've got the technology. We have the people. It's not like we don't know.
We're really working at it. And then they're so scattered and far between, and they're not, in groups and communication. Nobody knows who anybody is.
We need to get some victories under our belt.
Well, just like he mentioned, there was probably victories, but nobody really knows about it. And if there are any victories, you're sure they're gonna quash them real quick to make the news get out. They're gonna block that. But yeah, I think we have the knowledge, and we need some more fine minds to do the research and come up with the solutions. And we need to all band together.
Yeah.
How they conquer us is they divide and conquer us.
Yep.
Oh, you got one right here that's working on it every day.
But I think the expression of the trust is really the key. I'm switching all my commercial administrative remedies over to trust stuff, and I think it's
expression of your trust. But one of the things we're looking at doing is making them express the trust.
Yeah.
The way it's sitting right now before we do anything. And that way, when we come back later and we say, here, we're going to reorganize, we're going to do this, we're going to do that, they've already lost by acquiescence.
Yeah, well, I think the first thing we need to do is learn how to speak their language, because they're not going to pay any attention to us if we can't speak the foreign language. If we can't speak trust language, then we're not going to communicate with them. So first of all, we have to use trust definitions. It's not collapsing the trust, terminating the trust. We can't, pull these contracts. We're going to revoke these contracts.
Absolutely.
So we got to make sure we're using trust definitions, so there's no way of construing it otherwise.
It was brought to my point by another gentleman who's been studying trust for a very long time, and he was saying you got to change some words. So when they don't do something, you don't want to put in documentation, you did do something, you failed. You didn't comply. You didn't do those types of things. So you're absolutely correct on your language and your lingo.
Yeah, it comes down to, it's called precatory expressions of intent, and that's Precatory. And really that is weak language. It's not direct or commanding. It's not definite. It's not specific. It's not detailed, and that's why we're failing. The intent is uncertain, and when it's uncertain, that gives them the ability to come right in and construe it. As usually the settler directs or commands the trustee to manage the trust property for another, but on occasion she or he may simply express a hope or a wish or a suggestion that the property be so. But this type of expression is called precatory language, and whether precatory expressions create trust or only unenforceable moral obligations or less is a matter of interpretation. There's the construment right there. As a matter for the court to determine what the transferor or grantor intended. That's what our problem is. We can't speak the language. We can't be, we're too weak in our language. We're not direct, we're not commanding, we're not definite, we're not specific, and we're not detailed. And when we express the trust in our dentions, whether they're oral or written, that's what we need.
Well, and I think it comes from starting to understand where the ultimate trust came from. And who's the ultimate grantor? And who's the beneficiary? Once you start looking at this from a biblical or a scriptural perspective, everything changes. Literally, everything you'll look at, everything you say, everything you'll do will start to take on a whole new content. And so, I understand when Christ went to the cross, well, I guess it's pretty obvious who the beneficiaries are, depending on, your profession of faith. So if anything of what Winston teaches is the mirror image of commerce, then guess what? You're exactly right. It all comes down to the trust and understanding how to operate within that trust. You hear so many patriots talk about you need to know who you are, you need to know who you are. Okay, that's true, but you also need to know. I'm sorry?
I say they're parroting the terms.
Yeah, exactly. Oh, wow, that sounds really good. Well, yeah, Polly won a patriot. So, It just comes down to really understanding. I mean, imagine if you walked in the courtroom and the judge calls your name, and he's calling the all caps fiction, right? Because that's all he can call. So he said, is John David Smith here? And you stand up, and he says, are you John David Smith? And you say, well, which one are you looking for? Are you looking for the trustee, or are you looking for the beneficiary? And then look at him like, you know what? You want to come against me, pal? Let's fire it up. Then what is he going to do? Well, he's got a problem, because now you put that in the form of a question. Now there's a question on the floor. How many people walk into a courtroom where a judge asks you who you are, and you say, well, who are you looking for? Are you looking for the trustee or the beneficiary? That probably doesn't happen very often. Then he's got to try to lure you into controversy. He's got to try to lure you into the bar. Well, maybe you ought to tell him that your mother taught you not to go in bars because everybody inside's intoxicated.
Whoa.
So now what do you want to say, Judgy? Maybe my next question, I'm thinking in my head with a smile on my face, I wonder if he's naked underneath that robe. Yeah, he probably is.
I don't think I want to know that answer.
But I think you see where I'm going with this. So now maybe he's not ready for the next question. So every time he asks a question, he gets bit, and every time he asks a question, you bite a little harder. And maybe the next question is he bonded? Did he take an oath of office? Is his bond liquid? Well, if it's not liquid, then who carries your insurance policy? Are you a de facto corporation? Are you operating as a fictional character here today? Who's your surety? I mean, you just take him down through a series of questions. If patriots would learn one specific thing, and that is stop answering questions when you go in a courtroom and be prepared to ask questions.
Stop arguing.
Stop arguing. Stop letting them lure you into controversy. Just shut up and ask questions, because here's the bottom line. You're trying to ascertain what's going on. I need some clarity, Judge. He's not going to like that. That's where you hear stories about judges getting up and leaving the room. We had a little story here that happened not too long ago. Heard about a guy, judge didn't show. Oh, my. You mean he didn't show? And you sit there? Didn't know how to close the deal. So,
A little hot on that one.
Yeah. He didn't know how to close the deal. So not only did he leave the battlefield, he never showed up to the battlefield, for God's sake.
He left the battlefield, same thing.
Yeah, exactly. Yeah, he didn't show and he left.
Yep.
So, I think if it was me, and I was new at this, and I was just learning about all this stuff, and I was, trying to find remedy and trying to do all this stuff, if it were me, I'd be looking into studying everything I could about the trust and understanding how to operate within the trust. Because you're the grantor. You started this party with your signature on those documents, and you signed a power of attorney. You gave them full authorization to do whatever they want. And then we want to go in and we want to argue with them as little trustees when they're the beneficiaries. Well, that ain't going to work. No wonder they're not listening to you.
No,
you don't have.
Yes, the whole problem is the trust relationship. We don't know how to form it with them, because really you wouldn't have to go into all that detail that you just expounded on. Really, you could get them right into a trust right from the beginning, and then if you know how to enforce the trust, you could take it from there.
I'm working on that. I got some ideas I'm not going to talk about yet because I'm not sure yet, but I'm working on that. I think I have some answers in that direction.
Well, you're going to have to express the essential elements of the trust right off the bat. You're going to have to express the trust intent without putting in the precatory language. And you're going to have to make sure that you got the trust res in there and the parties to the trust, all the elements and stuff, the trust purpose.
What if you did it, when you did it, and everything you did had an OMB number tied to it?
There you have it.
Yeah, that's a form they can see, yeah.
I've got that. That's what I'm working on.
That's their language, too.
But you might want to have all this pre-done before you went in there and have it filed, and all you have to do is, catch them
in
the default of it.
Well, yeah, there was a well-known case, not well-known, but it was a federal case here just recently we were helping out with. I won't mention names or anything, but the gentleman had not given any jurisdiction in that time, and any paperwork, had not done anything before the judge, the first hearing, and explained to the judge, told him that he was the beneficiary, and the judge, in fact, does not have any jurisdiction in this case whatsoever. And the judge listened to him ramble and called another hearing. Actually, it was supposed to be 2 weeks later, and the judge ended up moving it up. Wonder why. And he was versed at that point on what to say on the record and what to ask on the record this time. And he got it all out on the record, and at the end, the judge didn't bother to tell him that they had switched the case number to a new case number. Now, what does that tell you?
I worked on that one too. Go
Yep.
ahead.
What does that? You know what I'm talking about, Harold? What does that tell you?
Actually, what he did in the beginning actually worked.
Yep. Same players, same everything, same charges and everything, except a different case number.
Sleight of hand.
Account number, different trust number. I mean, whatever you want to call it. So there's part of your proof. And then he turned and looked at the prosecuting attorney, and said, "Will you please plead to the defendant?" And of course, the prosecutor said, "Absolutely, Your Honor, I plead not guilty." Okay, well, if you knew trust law right then and there, you could have taken them all down right there and been done with it.
Yeah, because he took on the role as a trustee.
Trustee, he's called trustee, absolutely. Until the end, when they ask you, "Do you understand these rights that I've given to you, or you understand the sentencing?" and they say, "Yes, sir," or "Yes, I understand," okay, then you're the sole trustee. Goodbye.
You know, if you go, Winston's got an event coming up. Where is it? I don't remember, but I know it's coming up here somewhere in the country.
Ohio.
Oh, yeah, that's right. Yeah, it's in Ohio. Go look at what they're going to be talking about. You're going to see three subjects in there that we're talking about right now. It's about understanding the trust, the trustee position, and the beneficiary position. So, I think that's critical. I think it's critical. I think there's a main reason why a lot of people, got in trouble with the OID stuff.
Sure, it's unjust enrichment. The trustees claiming the money of the beneficiary.
And
that's correct. If you had been in a beneficiary position and you had gotten that refund, you know what? You may not have gotten it. They won't. I mean, how are they going to come after a beneficiary?
They're not. Good luck. If they do, you're another payday.
Oh yeah. And not only that, you just got to make sure you know how to, when you get the check or whatever, and you just write the right thing on the back of the check.
I've seen people get paid faster too, and all of a sudden the IRS realizes you know what you're talking about.
Right? Yeah, that really comes down to that. I think that's huge.
Yeah. Checks come back in weeks rather than months.
That's right.
Christian.
Yeah.
Do you know what protectorate means?
You were kind of muffled. What was it again?
Do you know what protectorate means?
Protectorate.
Yeah.
The protector, I would say, without looking at Black's Law, right? What is?
Well, it's not in the 5th. It's not in the 6th. So I don't have the other ones. I was just wondering if you guys might be able to quickly look.
Protectorate. I got a 4th, so.
I got a 7th here I can open up.
You might want to look at your 8th, Christian.
You guys need it too. Just as a side note, you're looking it up. I have blocks 1 through 7 all digitized.
Yeah, I'm supposed to be getting that soon, 1 through 7.
Now, if you need it, let me know. I'll send it over to you.
Okay, you can do that right away.
Okay, protectorate, a state which has transferred the management of its more important international affairs to a stronger state. It implies only a partial loss of sovereignty so that the protected state still retains its position in the family of nations. Moreover, the protected state remains so far independent of its prosecutor that it is not obligated to be a party to war carried out by the protector against a third state, nor are treaties concluded by the protector ipso facto binding many upon the protected state.
You want me to read the 7th? It's a little different.
Go ahead.
It says international law, the relationship between a weaker nation and a stronger one when the weaker nation has transferred the management of its more important international affairs to the stronger nation. Number 2, the weaker or dependent nation within such a relationship. Number 3, the period in British history from 1653 to 1659, during which Oliver Cromwell and Richard Cromwell governed. The British government in the period from 1653 to 1659.
Out of what you guys just read, is there a way to use that? I believe it's trust language, and I was thinking of using that word to make a trustee protect me. Would that work?
Why would you want to protect the trustee?
Well, actually, not. Maybe it's not to protect me, but to protect.
If you're going to be the trustee and not the surety, I'm interested.
No,
well, let's back a little farther to the Declaration of Independence. It talks about unalienable rights, and unalienable is transferable. So here we're talking about a protectorate that has transferred its management or its rights. So I don't know, on a grantor position, for sure, I wouldn't want to talk about protectorate, but maybe on a trustee position?
Well, I guess you could, if you were going to assign someone as a director trustee, that would be getting his orders from the beneficiary and the grantor, and then that trustee was going to be governing other trustees. You may want to use that particular language to protect the trustee that's handling handling the trust for you.
Or with an authorized representative on behalf of the trustee.
As an attorney in fact?
Attorney in fact or authorized representative.
Right.
Well, let's go at it as grantor, donor, grantor. That's like what you just read, or out of your head, I guess. That sounded really good. Because if you were to be the donor grantor and terminate a trust that you created, and you would assign the top trustee, I guess I would consider this person the top trustee, and assign my orders to that person under a protectorate, almost like a hold harmless too, I guess, in there, because I think that protectorate sort of has that cloud. And does that sound good?
I think I understand what you're saying, but as a grantor, I don't know that you need that. In other words, and his duties exactly. The grantor is already insulated. He's already protected. Yeah. Why? Because he has the trustees doing what they're supposed to do, as they are legally bound to do. So the trustee has to follow the trustee laws that are imposed upon him. So he better pay attention.
He's going to have immunity, but if he steps out of line, then he doesn't have the immunity. So that makes him vulnerable.
Yeah, exactly.
A breach of fiduciary duty and a breach of trust, and now you got damages against him.
Yep. They're not protected by the agreement.
So they could, or if you wanted to, it would depend on what you want to do with the trust. If you want to collapse the trust, then fire everybody.
Well, you see, that's just it. I don't think
terminate or revoke, not collapse.
Modify, revoke. Those are the words you got to use.
Yeah. My apologies.
Right. If
you want to shut down the trust, is what I'm saying. So if you were in a court case and you wanted it to go away, then I think you could probably use that approach. But I think it might be more beneficial to go ahead and assign somebody as a director trustee and have that director trustee tell whoever you assign as the trustee, the judge, a prosecuting attorney, a district attorney, a clerk, whatever, and then maybe you want to let them know that you're in on their little commerce investment off that court case, and that perhaps they created a bond and they took that bond, turned it into a security, and sold it on Wall Street. So
Don't want to go to the court now. That's not good. Okay? So in a court scenario, you're really asking the judge permission for anything you're doing in there. And as a grantor, you don't need permission from nobody. You're the main guy.
You're missing what I'm saying. I'm saying if you assign someone as a director trustee, and then that trustee tells the other trustees that have been assigned what to do, and let the court know that you're in on their little investment scheme.
That's true.
So maybe the SEC wants to get involved and have them come do an audit on that particular mutual fund.
Go ahead and file your 1099-As and see what they do on the mutual funds themselves.
Or how about assigning the IRS trustee duty as that main directorate?
How about Hillary?
Yeah, how about Hillary?
Yeah,
but
her assigns, yeah.
But I think the point is that once they know, it comes back to what Harold said earlier, and that is when you let them know who you are and you know what to do and how to do it, then the whole tune changes. Their whole demeanor, everything they do is going to change. Because, I mean, how many people walk into a courtroom knowing that as a defendant, they are nothing more than a trustee, and a plaintiff is nothing more than a beneficiary. And the fact of the matter is the court's making money off putting people in jail. So that whole dog and pony show of that investment contract that you're entering into. So when you walk in and you expose that and you let them know that you know that, now they realize that you know there's damages that can come, injury can come to them by continuing to peripherate the fraud upon you, the pirating and the plundering that's going on against you.
There's the word.
Let's back up and let's say you have a court case, and that court case, the indictment or the charge, that's actually going to be your NDI instrument. But if you never express the trust, you can't put that NDI instrument, that charge, that indictment, into trust deposit because you want the same asset back. But then you're not defining the indenture of the trust enough sufficient that they're construing it and they're putting you back under debtor-creditor law where they're turning that NDI instrument, that charge and indictment, and then they're securitizing that and running the bonds and all that stuff in the background and selling it, all because you didn't come in from the beginning and express that trust that you wanted that financial asset back.
Right. So that's where an abatement, and a strong abatement, and understanding the trust, coming at them from both sides of that, now they got a real problem.
Well, so set it up. You want that deposit back, that asset back, and then ask them for the asset back.
Well, and I would say we wouldn't ask, you'd demand it back.
Yep. Yeah, true. Right, yep.
Because then, again, that's where plundering and pirating comes into play. That's where they're looking at some pretty hefty jail time.
You got the deprivation of your rights in the color of law.
Yeah, that's where, because what they've done, obviously, that's gross misrepresentation of material facts, boys and girls. They did not disclose.
What we've usually done is we've come in and asked for a statement for settlement and closing. So, in other words, we want to play debtor-creditor relationship here, and we want to make a payment. We didn't have to make a payment. The charge or indictment was the payment, and we should have gotten that back because that was a trust deposit.
Yep, exactly, precisely. So now, when you're coming in and you're coming in at them with an abatement, and you're calling in, ollie in for you on the trust, that's not looking good, especially on a $75 ticket.
As you talked about earlier, give me all the assets that you've created off of that from my signature, my indictment on that, but those are all mine too. And if you stole all those, I got to have that back also.
Well, like I said, give them an option. Tell you what, boys, here we can do this a couple of ways. If you want, Judge, we can talk about this in open court, which I have no problem doing. Or if you prefer, we can certainly step behind the wall there and talk in chamber. But I want to talk about the trust and the investment that just happened and that little investment that's now out there on Wall Street. oh, gee, maybe we ought to step behind closed doors. Now, here's the bottom line, Judge. I'm going to give you two options. One option would be you can go ahead and reimburse me for that investment since you used my social and my living man, used my straw man to do so. Or maybe like option 2, we'll go ahead and call in the SEC and let them do a full investigation, include the IRS, and we'll see if we just can't have your charter removed.
Get your inspectors general to make sure that everything's being done properly.
Yep. You know, the IG's office will come in here, not a problem, and take a look around and see what's going on.
Yep.
What's the one-sentence expression of the trust that allows you to, do a hit and run until you're able to, say, sit down with somebody and really write out a good contractual express trust? What's a good two-sentence thing you can do with Hillary?
I had that 3-sentence opening up with the court without waiving any right, remedy, or defense, whereas I, the real man, am competent with intent and purpose as grantor/settler, and then that's where the footnote comes in. The expressed, revocable, modifiable trust filed, now coming as the beneficiary in the above-named action in good faith states as follows.
Or you can send them standard Form 85P.
Was in the unlawful or illegal purpose in construing trust, unlawful purpose should be not imputed to the settler, and then a case cite. And then the purpose for which the trust may be created, and quote, the intent and purpose of the settler is the truth is the law of the trust, unquote. And then 3 other cases. But there it is, the intent and purpose. And then you could probably modify this a little bit more and say, okay, make an attachment and see the attachment for details.
Well, you could take the summons and just cross out
Chambers.
Take a summons and cross out the words defendant and cross out the word plaintiff.
Yep.
And fill it in and put trustee beneficiary.
Check out standard Form 85P also.
There you go. There you go. That's you write that one down, guys.
Say again, standard form what?
Standard Form 85P. It's a GSA form. Make them express the trust. Got no MB number on it. You got to tell me who's running the show.
85P is in Papa?
Yep. SF 85P.
Or piss their pants if you prefer to do that way.
Don't forget, it's the trust is the relationship with respect to property, and you have to define that.
Yep. 11-page form. They better fill it out.
You got to have the trust intent. You got to have a specific trust res. You got to have designation of the parties, and you got to have a valid trust purpose. If it doesn't meet those elements, you don't have a trust.
And that's over and above when you want to go in and talk about ratification of commencement and where's your claim, where's the injured party, no claim, how can relief be granted? What jurisdiction are we operating under here today, boys and girls?
Hey, I go by that the line that was told to me a couple months ago. Okay, I believe you. Uh-huh.
Yep.
Sure.
Yep. Sure. Not a problem. I believe you. You betcha. Not a problem.
Who's this? Who's that?
Just asking a judge by, what jurisdiction are we operating under here today? That throws a wrench in the works. And whatever he says, he could say, we're operating under the da-da-da-da District Court of Chicago, blah, blah, whatever. No, I didn't ask you location. I asked you what jurisdiction. Are we operating under admiralty, maritime, statutory? Under what jurisdiction is this court operating today? I need to ascertain what's going on. Judge, I'm asking you.
I went to a court case. They tried to get me on it was a traffic incident, and I went in chambers because I was asking all the questions in open court they didn't want me to. And I asked him, it took me 3 times. I asked him 3 times what jurisdiction we're in. Finally, he was statutory. And 4 days later, they dismissed the case.
Oh, statutory. Great. Can you provide for me, Judge, the manual on rules and procedure for statutory court? I've looked and can't find them. I've looked all over. That's right. Exactly. Thank you, Harold. There is no such thing. Well, gee, if there's no book on rules and procedure, I guess this party's over. Yep. How do I know if I'm violating the rules of procedure or not? I don't even know what they are. Yeah, gee, and if you don't have a manual, how do we know what's going on here? Yeah, at that point, once you've got him by those short ones, what's he going to do? He wants you out of there because you're wasting his time. and you're not low-hanging fruit, and, you know, you're damaging. You can injure him. So he wants you out. Dismiss the case, dismiss the case. That's when you go, no, I don't give you permission to dismiss the case. This ain't over yet. I have another question for you. I have another question for you, Judge. Where's my money?
When you file a claim afterwards and they even dismiss the case, the claim doesn't go away.
Where's my money? I want that money that you sold over there on Wall Street, bub. That's what I want. So tell you what, it's over providing you tell the clerk to write me a check for the amount of money on that bond that you just created behind my back.
Or do I need to notify the mutual fund advisor, the hedge fund manager, because I have his name and his phone number here and his address.
By the way, have you seen
beneficiary in town, and you start sending proceeds over here every quarter? Is that what we need to do?
Yeah, exactly. And you know, if you have a CUSIP number and you at least have some idea the value of that CUSIP number and the leverage that CUSIP number will provide you, I mean, how many judges do you think where somebody walks in and says, "Hey, Judge, by the way, I got a couple questions for you. Are you familiar? I see here that you're a de facto corporation, that you got a Dun & Bradstreet rating. By the way, this court case, have you heard of CUSIP number blah, 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 blah? You might want to ask your clerk there."
You guys know where Dun & Bradstreet came from? They're not people.
No, they're not.
Nope.
No. So, you know, like Christian said earlier, I think he's spot on. I think what's happening is that's what we need. We need a group of people. You know, can you imagine 100 people like us right here, right now, put together with like minds who are really pissed off?
With some foundational knowledge and trust, yeah.
Yeah, exactly. With some foundational knowledge, and we're all watching each other's back. And imagine if, 10 or 20 of us walked into a courtroom to help somebody who's getting foreclosed on. By the way, go look up the word foreclosure. It was foreclosed at the table when you signed the note. You foreclosed right there. That was the foreclosure. By the way, guess what money they use when they buy back your property?
That note.
Yours.
That alleged note is what they use to purchase the property with.
That's right. Now, if that doesn't piss you off, then there's more. It gets worse.
Because actually, that money that's hanging out in escrow, that the principal, that face value of the note, that's what they're going to use.
What they're going to use.
Then they fractionalize it.
Yeah.
Oh, you betcha. And by the way, I'm sure they disclosed that at the table, right? When you sat down and filled out all your paperwork, they told you about all that, didn't they?
Of course.
Wow.
Of course
Sure.
they did not.
Yeah, why do they call it the closing table? Why do they call them loan officers? Really? An officer? Wow, were you commissioned? Were you appointed? Were you elected? Oh, wow. So then what kind of an officer are you?
They don't know themselves. They don't even know what they're doing most of it.
That's right. That's what's so scary.
I did it for 5 years. I know exactly what you're talking about, Harold.
Yeah.
If somebody would have asked me, what the heck is a loan officer? I would have said, well, I just help you get your loan.
Yeah, well.
Not knowing that there's no loan going on.
Exactly. Now I do.
It's all an investment transaction.
So it's all that psychological programming crap, too. You know? We lie in this country. People don't realize that, it's interesting. I think there's people out there that feel there's no such thing as an inconsequential lie. I would disagree with them wholeheartedly. Why do we start lying to our kids from the beginning? Tooth Fairy, Easter Bunny, Santa Claus, Columbus discovered America, Federal Reserve is federal. And when you buy a house, you need a loan officer. I mean, come on. Where does it stop? The whole banking industry is nothing but one big, gigantic freaking lie. And guess what, boys and girls? For the ones that are on this line and you alphabet soup site, it's coming to an end. It will end. It's going to happen.
Creditor law, U.S. statutes.
You can only cover it up so long. Well, there's millions of people that know what's going on in this country today. So, let's line them everybody up and shoot a little mercury into their body. And a few other toxins and poisons.
Well, they're already dead already. We just keep giving them energy.
Yeah. Well, but I think I truly believe there's a shift in consciousness going on. I think there's a whole bunch of people, there's a lot of brilliant minds behind the scenes. These calls are great because what it does is it gives people an opportunity to come to a forum, and, you don't have to take our word for it. Go research this stuff, man. We're not making this stuff up. This stuff is out there. It's available to you. You got swindled, including you alphabet types. They swindled your ass, too. And, these makers they're using you. They are using, they ought to just call you bitch because that's what they're doing. They are using you big time. And they're continuing.
The way I put it is that they're the master pimps. They're pimping us in so many ways. First of all, they pimp us at that closing table to agree to pay their taxes on their investments because that's what those mortgage payments are, basically payments on the taxes. Then they go turn around and say, well, if you default, we're going to take the house too. So they pimp us all the way around.
This is Pat in PA. Can I get a question in?
Yes, you can.
Say you have a $100,000 house and you took a mortgage out for $30,000, and they foreclose on you. Is there a way that you can make them give you back the $70,000 that you got into the house?
What did they buy the house for?
Pardon?
The amount. What was the amount the house sold for at auction?
Well, they usually get it for the same price what the mortgage is. What's owed on the mortgage?
That's not my question. You need to know that. Otherwise, we can't answer your question.
And it depends on which state you're in. I'm not sure in Pennsylvania, but I know here in New York in particular, the bid is at the mortgage amount, whereas in some other states, say like in Ohio, they'll start with a lower bid and then move up. So it depends on what state you're in.
Depends on whether you actually have an investor who's buying the property or the bank's just buying it back. Well, that's a real interesting question. If the bank owns the damn thing, why do they have to buy it back?
That is a good question.
Because they don't own it.
Can you still ask for the note back if they take the house?
Sure. Why can't not ask? Ask my butt.
Tell them.
Demand. You demand, and if you don't, take them to federal court and demand that you get the note back. You can't have it both.
Who gave them permission to sell it in the first place?
But if they do get the house per se I owe $30,000 on the house, the house is valued at $100,000. I've got $70,000 interest in the house, equity in the house, and they get the house back for $30,000. Can I?
Wait a minute.
Yeah.
You've got a perceived value of $100,000.
Well, I put $40,000 down on it, so that gives equity right there.
You're missing my point. You got an alleged perceived value of $100,000 on a house.
Right.
You bought it. You put $30,000 down on it. Let's say you made payments all these years, and then now you only owe $70,000 on it. Whatever. My point is that when they sell it at auction, whatever that price was paid, you would be due the difference. Let me give you an example.
Okay.
I have a friend of mine. When he found out about all this stuff, he said, "I'm not doing this. I am not paying these bastards any more money," and he stopped. He had a $140,000 note. His property was worth $1.6 million. Okay, 85 acres, 8,500 square foot house, pool, hot tub, tennis courts, the whole 9 yards. Beautiful piece of property. They sold it at auction on the courthouse steps for, I think, $630,000. So they subtracted the $140 that they alleged he owed from that $630, and then they charged him up the butt with a bunch of other fees and court costs and attorney fees and all this other stuff. And when it was all said and done, they wrote him a check for the balance. So that's how you can equate what might be coming back to you. In other words, if you had $40,000 worth of equity in your home and it was a $100,000 house, but they only sold it for $45,000, then you'd only be getting $5,000 back or whatever was left after they stomped all over. Does that make sense? You follow what I'm saying?
Okay.
Or if he actually inputted equity into the house, whether it be monetarily, sweat equity, or anything, he can demand that back under just compensation.
That's correct. Of course, you're going to have to go fight them in equity court, which may not be that easy to do. What you could do, though, I think, is that, look, like we said earlier, you want the house? Come take it. You can have it. We'll clean the carpets, and there's fresh cookies sitting on the counter. But I want the note back, and I'm gonna run a QSIP number, and I'm gonna see if you turn that note into a security. Oh, you did? Okay. Well, then we'll find out what fund it's in, and then you're gonna give me that back because you altered the note. It's no longer a collateralized instrument. Now it's a security. You turned it from a collateralization instrument into a security instrument. That changes the whole ballgame. Now you owe me money, but you're going to have to take them to federal court to get it, more than likely, unless you can draft the right kind of paperwork and, maybe put a little pressure and let a certain banker type know what you want and, it's ollie in free and I know what's going on. But I would still recommend, even if you're going to do that, you still have to go back and establish your position within the trust as the grantor and resign as a trustee and appoint yourself as the beneficiary. You must do that because if you go screaming at the bank, even after the fact, screaming for your note back, you're screaming as a trustee. What rights does a trustee have? None. Trustees can't make demands upon the trust. So there you have it.
Trustee takes orders.
Trustees takes orders. That's right.
He's got duties, responsibilities.
Fiduciary responsibilities.
What you may want to do is if you know somebody that you know and trust who's a really good notary and knows how to, move about the country as a notary, especially notary presentment, you may want to ask him, and you may cut him in for a percentage or a good part of it. I certainly would if it was me, based on what you're telling me, and go have the paperwork drawn up and assign him as the director trustee, and or even maybe an attorney in fact, and let him go do it for you. So that way you're doing the same thing they're doing. What do the banks do? What do? They go out and hire law firms, right? And the law firms and the attorneys are out doing their dirty work. So, if you know a good notary, again, based on what you're telling me, if it was me, that's what I'd do. And let a state official go put the paperwork forward and demand the note back. And if they don't bring the note back, then maybe they'd like to explain this QSIP number and the investment. Maybe you'd like to put a subpoena ducis tecum on the CFO of the bank. Let him come explain what's going on. Maybe you'd like to explain, and maybe you'd like to ask him as one of those questions, did you ever take that note and turn it over on the back and stamp it, pay to the order of without recourse? Oh, you did? Oh, wow. Oh, you didn't? Are you sure?
How do you find the QSIP number, though?
You have to get the QSIP number. You can typically buy them, or you can find them. Send an email to this group with your name and information, and they'll forward you some information where you can go request a QSIP number.
What number is that? Or
Matthew?
Yep. The
email
is QSIP numbers@hushmail.com, and that's spelled CUSIP. C as in Charlie, U as in uniform, S as in Sierra, I as in India, P as in Papa, QSIP, and then the word numbers, NUMBERS, @hushmail.com. And that's one word, all lowercase, no spaces, QSIP numbers, plural, NUMBERS, @hushmail.com.
Thank you very much.
And what do they need in there, Dave? They need the mortgage company, the mortgage.
I think Yeah, the account number, and what, it depends on, there's a lot of different customers. I guess it depends on what they want. In other words, if it's a Social Security number or it's a birth certificate or whatever it is, if it's a mortgage, then you'd want the name of the mortgage, the bank, and the account number.
Yeah.
Because mine was sold, it wasn't sold per se. Ames had it originally, then it was transferred to another collection agency, which was the same part of Ames. Then it was transferred to Fairbanks. From Fairbanks, it was changed to 2 or 3 others, and then it was changed to Select Portfolio Service. When I asked Select Portfolio Service for a copy of the note and the mortgage, they said that they no longer had it. It was destroyed. They couldn't find it. And then going on the internet, I found out that they sold it a year and a half ago to Fannie Mae.
Well, what are they going to sell? They have to have something to sell.
Evidently, they sold the note or the mortgage.
Well, wait a minute. Wait a minute. Think about this for a minute. If you were going to go out tomorrow and you were going to buy an automobile, all right, and you picked out an automobile from a private person, and you guys came to terms on a cash price, and you went to go pay the guy cash, what would you want in return?
A receipt.
A receipt? What else would you want?
The keys.
Well, but wouldn't you want the title or the pink slip or something that showed?
Okay.
So how can a bank sell its interest in a property to another bank? What's it going to sell? It's got to have some paperwork, doesn't it? Well, what's the collateralized paperwork? The note. So what we tell the stupid public out here is that we lost it, or it's not available, or it was destroyed. Poppycock. That's what they want you to believe. Oh, gee, it's been destroyed.
Well, that's what Deutsche was doing, but for the insurance purposes of collecting on, because they were buying defunct loans, properties that they didn't have the notes in for, but they bought them anyway because they could turn it in for the insurance and collect on the money even though they didn't even have the notes.
And there's another idea. Kristen just brought up another great idea. Why not you guys paid for some title and mortgage insurance, right? Well, you paid for it. It came out of your funds. It was your Federal Reserve notes that paid for it. But who's benefiting from it? Well, wait a minute. Hold on a second here. That's almost like saying if a guy stole your car, right, and then, you paid insurance, well, then would you want your insurance company to pay for the damage that he did to your car? Or would the person who stole your car be liable for the damages that he did to your car? If that makes sense. Well, if you're paying for the insurance every month, then why does the bank benefit from that insurance? You paid the bill. So if it was me, I may want to contact my insurance company and tell them that I demand to know where the note is. Where's the collateral? How do I know that they're not out? How do I know that somebody bought it out there? And if you don't know where it is and you knew when it was destroyed, well, did you report it? Did you report it missing? You had a fiduciary responsibility to do that. So, what happened? So how do I know you didn't sell it to somebody who hasn't sold it to somebody else who's going to come back 2 years down the road here and try to collect more money from me because they've got the note? Because XYZ over here sold it to ABC and ABC sold it to CDM. Can you guarantee me that? To me, that's a pretty strong argument right there in federal court. What's going to protect me from somebody coming back 5 years from now that says, I've got the note on John. You owe me, John. Not to mention the fact that the bank's going to come back and they're gonna hit you with a 1099-A. Well, how are they going to do that unless they had the note? How many foreclosures out there are people getting hit with 1099-As? most of them. So now, not only did they throw you out in the street, not only did they lie and create fraud in the inducement, a gross misrepresentation of material facts. They took your money, they fractionalized your note, they cashed it, they deposited it, they turned it into security, they sold it on Wall Street, they sold your property, paid for it with your money, and now they have the audacity to come back and fill out a 1099-A on you and submit that. And you wonder why we picked up arms and marched against the Redcoats.
Well, I could actually ask my insurance company to request that the note and the mortgage is still in their hands to validate it.
Well, but your insurance company, it won't be in possession of the note.